Let's talk a little bit more about Proven Industries versus Trevor McNally. Now, if you haven't been following this one, I've done several videos on it, but Proven Industries is a lock manufacturer, and they made a video where they basically were showing off how awesome their lock is. They say you can't get into this with a whole bunch of different tools and techniques. But they also posted a comment where they essentially called out Trevor McNally and said he's not going to try to break into our locks, he only goes after the easy ones. So, what does Trevor McNally do? Well, he's a guy who breaks into locks for a living and posts it to YouTube. So, he breaks into the lock and posts it to YouTube. And Proven Industries is really upset because they say he makes it look so easy. He just uses a bit of aluminum can, and they say there's no way it's actually that easy. There's no, he's leaving out all these things. So it's a very bad lawsuit. I've been laughing at it because Proven Industries really should have known better than to think that a lawsuit's going to help. But Proven Industries filed a motion for an emergency injunction. They wanted to prevent Trevor McNally from making any more videos because they said, oh, listen, his test was, here's how he faked it. And so he put out more videos to say, no, I wasn't faking it. Look, I've shown all the things. So they are like, please stop making videos that contradict our defenses. Yeah. Anyway, the transcript of this motion hearing is something that Proven Industries does not want released. They have filed an application to keep it under seal. They want this locked down tight. Good news is I kind of know their secret weakness. So here's the transcript. Yeah, we're going to go over it. Now, one of the things that they are upset about is they say people might take quotes out of context. Well, it's 129 pages. We're obviously not going to go through all of it. But I'm going to try to keep within context. Let's have a look. Now, I will note that the judge on this one, Mary S. Scriven, I really like her. She gives some grief to both sides. She does not seem to have a whole lot of patience for BS. But let's look at some of the key moments that happen in this hearing and talk about the results. So, the first one is the court wants to see the magic trick. Court's like, you're going to show me this. And they run into some issues. And this is actually a place where the court is giving grief to the defense, or to Mr. McNally's side. So the court says, okay, and the defendant for his part says he can pick a lock without altering the lock system that exists on the plaintiff's locks by cutting a monster beer can into a sheath and sticking it in the lock and turning it and popping the lock off. Now, I think some of this is probably that the court, I doubt the judge drinks Monster, because Monster's an energy drink, but also some of this may also be computer-aided transcription, because I suspect that's just shim, but I'm not sure. Anyway, I'm not going to fault the court too much because I don't know how much of this is, weird transcription issues. So Mr. Turkle, who is counsel for Mr. McNally, says, yes, Your Honor, he doesn't actually say that. He does it on the video. And the court says, well, he is by implication saying that the plaintiff's assertion that their locks cannot be broken is false, and I'm going to show you how it's false. I'm going to cut open a beer can, cut out a sheath, I'm going to stick it in the lock, and I'm going to turn the lock and pop the lock off, and you're going to lose your van or your motorcycle or your fifth wheel. That's his whole point. The judge is just getting right to the issues here. Mr. Turkle says, yes, Judge, the one video that was framed within the pleadings, they filed a motion for leave to file an amended pleading yesterday. The one video that was within the four corners of the pending pleading, I don't believe there's any statements at all. There's just literally the exercise of popping the lock. Now, the amended pleading is that Proven Industries was upset that Mr. McNally keeps putting out videos, and so they want to amend to include all of the new videos that he's put out. And the court's going to grant that because reasonable for them to grant it. There's no reason for them not to. So the court says, well, he's not doing that for his own edification. He's doing it to demonstrate the lock is penetrable. The thing is that's not entirely why he's doing it, because he's also doing it to demonstrate that Proven Industries' criticisms of Mr. McNally are not correct, because Proven Industries basically said there's no way he's going to come after our locks. He only goes after the easy ones. So he's not just doing it to demonstrate that the lock is penetrable, but he's also doing it to demonstrate that he is not this sort of, huckster that they accuse him of being. And I think that's going to be a critical moment if this goes to a trial. We'll see more of that developed in this. So Mr. Turkle says, absolutely, Judge. I'm just clarifying that. And the court says, he doesn't say it out loud. He agrees. He's not saying anything out loud. It's not the standard defamation case where discrete statements are identified in an implication setting that together create an implication. They're basically saying conduct. And the court says, okay, well, isn't the first order of business to demonstrate whether it's true that he can open this lock? Don't we need to know that before we know anything else? Now, I don't necessarily agree with the court, because at this stage, we don't need to know that. That's a trial stage issue. But it is relevant here, and the defense is not going to do the magic trick. They're not going to show off in court today, but they do end up getting to where they need to be. And we'll talk about the difference between sort of the best possible scenario versus what they need to prove or what they need to establish. And in fact, they don't need to establish anything, because it's the other side that's trying to get the injunction, and the burden is on the people asking for it. But yes. So, the judge says, Judge, I heard it's true, and I didn't hear after that. And the court says, isn't it true that the first order of business is for us to ascertain whether he can open this lock or not? He says, he does it on the video very clearly. And the court says, has somebody got a beer can and a shim and a lock? The court's like, do the trick. I want to see it. And quite frankly, I suspect that if they had just shown that, popping open, the court would have just said, okay, we're done here. Proven Industries, you're not getting your injunction. But instead, they're going to go through some evidence. And I suspect part of why the defense here, Mr. McNally's team, and I'm not, I don't have any sort of special knowledge of what they're doing. I'm just kind of gaming it through myself, is that they actually want Proven Industries to bring some evidence and to cross-examine. And they want to keep as much as they can sort of for later, right? They want to keep as much as they can close to the vest. So Mr. Turkle says, I will tell you this, Judge. If the right controls were in place and we knew we were getting the lock that you get retail, that would be subject. We could indulge it. But right now, Judge, I think the first order of business, there's 2 or 3 of them. So housekeeping, for instance, here's going to be a big problem with doing the trick, which is that both sides are going to accuse the other side of malfeasance. So, if Proven Industries brings in a lock and says, go ahead, they're going to say, how do we know that lock hasn't been made specifically extra difficult? And if Mr. McNally brings in a lock, Proven Industries are going to say, how do we know you haven't tampered that lock and made it extra easy? This is the kind of thing. This is the OJ's glove moment, right? Nobody wants to be the side that made OJ put on the glove, because if you do and it goes badly, then things go real bad, right? So the answer is, I'm not going to get to see the demonstration today. And you can sort of hear the disappointment in this transcript, right? Mr. Turkle says, Judge, I don't think we could be compelled to do it. I don't think that anything framed by the court says, so the answer is, I'm not going to be able to see the demonstration today. Is that correct? It's like, don't dodge. I asked you a question. Answer the question. I kind of hate appearing in front of judges like this, because sometimes lawyering is about dodging the questions. But I have tremendous regard for judges who do this, notwithstanding the fact that sometimes it can be an issue for me. So Mr. Turkle says, I'm not going to say that to you, Judge. If we could get the right situation, we know we're getting a lock that hasn't been messed with, and we know there's a chain of custody, so we know it hasn't been altered at all. I mean, I did it yesterday, so, I'm not worried about the ability to do it, but note the little drop there. The lawyer is saying, I did it, and I'm a lawyer. I'm not Mr. McNally. I'm not the super expert. I'm just the lawyer, and I did it, so I know it can be done, but we don't want to be in the OJ's glove scenario, right? Court says, the answer is, Judge, we are not today prepared to make a demonstration. And Mr. Turkle says, Judge, I'm defending. And the court says, yes or no? And Mr. Turkle says, we didn't plan on it. The court says, okay. He says, but I don't plan a lot of things when I'm defending. And his point here is that he doesn't actually have the burden of proof. The burden of proof is on the plaintiff. The burden of proof is on Proven Industries when they're asking for this emergency injunction. And in fact, it's a high burden. And so he's saying, like, we don't have to prove anything until they've established a case, and we don't think that they can. So we're not doing a demo because they have the burden and they can't meet it. So why would we be doing tricks here? Court says, did the plaintiff bring a lock in a beer can? And Ms. Ellis, for the plaintiff says, no, Your Honor, we didn't. And if I could make a note, I think a part of the issue and why we allege that it's defamatory is because, the locks are being opened and manipulated in non-real world circumstances. So Proven Industries doesn't want to bring one of these locks in either, and because they're worried that he's going to open it in the courtroom, and they're going to say, well, that's not the same as if you opened it on a trailer hitch. Thing is, if I was going to try to show that it can't be opened on a trailer hitch, and if I was confident that it can't be opened that way and that Mr. McNally's full of crap, and I'm the plaintiff trying to establish this, I would have brought in a lock. And I would have brought in one that's attached to a trailer hitch, and you can just set it on a chair somewhere and say, you can't move the trailer hitch, so you've only got that range of motion. Demonstrate. But then you get the OJ's glove problem, and you lose. So the court says, I understand the argument, but the truth is an absolute defense to defamation, and whether or not Mr. McNally can open your lock by creating a shiv out of a beer can in real time would determine whether he's making a false statement, setting aside all the other challenges to the claim. But that first challenge is the ultimate challenge, because if he can do that, then wouldn't you agree it's not defamation in the sense that it is not a false statement concerning your product? And Ms. Ellis says, yes, Your Honor. No, I would respectfully disagree with that. So yes, but no. I think it could still be defamation by implication, even if he could open the can, or even if he could open the lock, open the lock with a beer can, for instance. Court says, how? Ms. Ellis, again for Proven Industries, says, because it's not real use or a real world situation, right? He's manipulating the locks. He's able to access it, put pressure on it in a way that one would not be able to. A normal, regular customer who does not have the expertise that Mr. McNally has evidently demonstrated that he has, and the capability and the experience and the hundreds of hours of having to shim these locks, wouldn't be able to do that. But more than that, in a real use situation, Mr. McNally would not be able to manipulate the lock in the way that he does and open it, and I think that it creates a false implication that the product is not secure because of the way that he's opened it. So this really opens up, I think, a major issue for defense strategy, because Proven is saying, listen, your statement here is that these locks are bad. Whereas I think there's a real argument to be made on behalf of Mr. McNally, and again, I'm not his lawyer, I'm not advising him, I'm just talking here, that Mr. McNally actually included in his video Proven's little call-out message. And because of that, it actually seems that there may be a really good argument that that Mr. McNally's statement here and the implication is actually a statement about Mr. McNally and his skills. And if that's the case, then the only thing that's relevant isn't, whether I can get into this thing, although I did, but the implication becomes whether or not only Mr. McNally can. And that's a much easier case for the defense, because if then it removes that whole question of, well, do you have to be an expert? And the defense is actually going to do a really good job of attacking that. And so let's skip forward to the next bit I wanted to cover here. Again, there's 129 pages. I am not going to go through all of them, but we're going to go through some of the moments that I thought were the most critical moments. So this is, they've got their witness here. It is Anthony Sansone, and he's being asked questions here. So question, okay, the latch pin locks that you've come to understand that Mr. McNally, the defendant, was able to bypass, were they the least secure or the cheapest option that was available by Proven? And he responds, they're one of the more entry-level lock cores that we offer. And then question, let's ask about the padlock. Did you come to understand that Mr. McNally, the defendant, bypassed a padlock as well? Yes. And what are the typical uses for that? The padlock can be used to, it's a standard padlock. So anything that you can attach a padlock to, any two aligning holes that you want to maintain aligned, you can install a padlock. And the question, and does Proven offer, like it does with the latch pin lock, different internal core mechanisms for that one as well? And he responds, yes, all of our locking products can have all of the cores interchanged. That's one of our features we offer. And then the question, and is it your understanding, based on your review of Mr. McNally's videos, that the padlocks that he bypassed were for the most entry-level and the cheapest product line? And then the answer, it was the same lock core that was present in the latch pin lock. So one of our standard, we'll call it standard level lock cores. Because they don't want to say, hey, listen, we make a garbage tier lock. And, certainly that's not their position. They're just saying we have a cheaper version and a more expensive version. And they actually note that the sort of thing that lets you get into this one by shimming and is a feature that is just on the cheaper tier lock. The more expensive tier lock, they say, is resistant to shimming. Well, this seems like a pretty easy solution. Quite frankly, maybe you want to stop selling the cheap tier if you are selling this as a premium product, right? If you're selling these locks as like a premium, and like this thing's expensive, it's like $130 US. If you're selling it as a premium product, maybe include the premium tier stuff as the basic, right? As your lowest level, because otherwise you open yourself up to this kind of thing and you run into some serious difficulties. Okay, so skipping ahead a little bit here, and these are questions, by the way, by Proven Industries Council, so this is on direct. So question, okay, and I know you've indicated that there are different internal mechanisms. Did Mr. McNally in his video number 6, in his attempt in his bypass of the puck lock, what internal core mechanism did that lock have? Then the answer is the same as the other products. It's a rotary disc detainer style puck lock. It's the standard core we offer on all of our products available on Amazon. The response is, or the question, and that's the most basic core, is that correct? Then it's one of our 2 entry-level cores we offer. So this is kind of a problem if you're offering a premium product. You should maybe make sure that the premium product is, up to spec. So question, and when we talk about product testing, well, let's talk about product testing. Does Proven conduct any product testing to ensure the security of its locks? The answer, we do, yes. Then, okay, describe what that is like. And then this answer from Proven's own counsel is actually kind of, or from, this is on direct, so they should be avoiding all the landmines here, but this is not actually a great answer. Our Proven's product testing revolves around feedback we receive from customer service and from our customers through customer service. So based on customer questions, customer complaints, we want to ensure that the products suit the needs of what is being seen in the industry in terms of security breach attempts. Here's the problem. So they're saying, listen, we do testing based on customer feedback. So let's say I'm a customer and I have a lock like this, right? And let's say my trailer is stolen and the lock is not found, or it's like they just leave it, behind at the scene and whatever else. They're probably not going to think shimming, because police officers are not security experts, believe it or not. They just don't necessarily know what shimming is and so forth. And so what typically gets decided if they find like the padlock is, or the hitch lock or whatever is left behind or just missing, if they don't find pieces of it, they will typically sort of conclude that you just didn't put the lock on, that you forgot. And when they conclude that you forgot to put the lock on it, that actually has some potential consequences. They can say, well, this was stolen, but you didn't put the lock on it. And then your insurance might be less inclined to pay out if you didn't lock it, in their view, than if it's shimmed. Now, based on sort of my playing around with this, I suspect that a forensic locksmith, and those exist, people whose job it is to take apart locks and figure out what happened, could probably, using, microscope analysis and so forth, could probably look for little microscopic tool marks of scratches and so forth to see that it was in fact shimmed rather than opened with a key. They'd be going in and looking for little scrapes and scratches made by the bit of pop can or whatever else. But most people aren't hiring a forensic locksmith. They're tremendously expensive. And so your average customer isn't necessarily going to know this. Now, I am not in the lock business. That's not what I do. It's not, but if I was suddenly going to decide, you know what, I'm going to make locks. That's what I'm going to do. I would probably look to set up a relationship, like on an ongoing basis, with, somebody like Lockpicking Lawyer or Mr. McNally or, I don't know what Bosnian Bill's doing these days. Deviant Ola, all of these people, right? There's lots of people out there who, defeat locks and defeat security stuff as their business. And so if I had a brand new lock that I wanted to bring to the market and I wanted to sell this as the best lock out there, I'd probably go to each of them and just say, hey, here's $5,000 for your time, and an additional $5,000 if you can get into this. If you can beat our product design guys, you get the bonus. And then, and you have to tell us how if you do it. You have to explain how, and we're going to put you under an NDA because we're sending you products that are still under development. They're not for public release, so please don't embarrass us that our beta version is not good. But it wouldn't be hard to hire people to go and try to break into stuff, right? I don't know if the numbers I picked out of the air or what they'd charge. They might charge a lot more. They might charge a lot less. But just say, hey, we want you guys to try to break into these things, because lock design is inherently adversarial. It's a lot like the criminal justice system, right? Or the court system. The court system, we decide that we're going to get to the closest we can to truth by having one side argue one position and another side argue the other position, and whoever sort of is able to best sell the day to whatever appropriate, legal standard is going to be the one who wins. You want somebody who's not like in-house. You don't want to ask the engineers if it's secure. You want to ask somebody whose entire job it is to make your engineers look stupid. That's who you want to test. And customer feedback is not a good way to do this, in my opinion. So, all right. Skipping on a little bit here. So they have a video that's played here, and they're asking basically what is missing here. Like what's the defamatory aspect here? All right. So, from an engineering standpoint, and again, this is from Proven's counsel, what critical facts are omitted from the video and Mr. McNally's shimming of that lock? Then the answer is, so from an engineering standpoint, the product appeared to be pre-installed on the trailer. The custom tool was pre-made, assumingly with measurements taken to determine the correct size and shape and form of the tool. Now, that's a big assumption, right? Because I am not a super expert in this, but honestly, from my playing around with it, it doesn't need to be an exact shape. There's a lot of wiggle room for error, because all you need is something that can slide in between these, in that gap, the metal gap there, and that has some sort of hooking shape and critically is not gonna, fall apart. Those are kind of your three things, but it doesn't hinge on some special secret sauce. I was able to do it just by looking at Mr. McNally's videos, so yeah. The core used in the lock is, as I mentioned before, our parts are made for the cores to be interchangeable, so it's unclear from the video whether or not that's a core that came with the lock or not. I can assure you that when I was doing my testing, it was with a core that came with a lock. So question, okay, was there any information that you believe that would have been omitted regarding Mr. McNally's preparation in order to open the lock or his inspection of the lock? And that gets objected to on the basis of you don't have a foundation for that, so we'll skip ahead to when they do try to get to a foundation. So, answer. I attempted to recreate the shim shown in the video and bypass the lock in a similar method shown. Then the question, describe how long it took you to do that in the process. Give a little bit more detail. So the court says, well, first of all, were you ultimately able to shim the lock using a device made out of a piece of aluminum? And the witness says, eventually, yes. This already is a really bad answer because Proven Industries has admitted in court, they've called their own witness who has said, hey, we were able to shim these locks. This should be the time when you are not suing somebody, but instead you're fixing problems, right? So this is like saying, well, we were able to, get the car to explode into a ball of flames, killing all occupants, but it didn't happen every time. Yeah, okay. So the court says, and how long did that take you? And witness says, I wasn't able to do it after this video. I was able to do it after the subsequent videos that showed the cutaway, more detailed view of the exact method of shimming. I don't have a lot of experience with shimming locks open, so my initial attempts after this video all ended with the shim breaking off. And then question, and how long did you attempt after watching this first video to open the lock? How long would you say? And answer, I would say I made approximately a dozen different shims. Then the question, 12 different shims and they all failed? Correct. I found this to be the most challenging part as well, which is that the shims can break. But if the shim doesn't break, it can be done. I have since played around with this a bit more, and I've sort of managed to replicate the clean open that Mr. McNally does. And the critical thing is your shim can't break. My first open on this lock was I got it wedged in, and the broken off piece actually jammed the thing shut. But the durability of the material is sort of the critical element of this. And quite frankly, I think if I was able to make a shim in just very broad sense out of a stronger material, like a purpose-designed shim made out of steel, I don't think you'd have a whole lot of difficulty with this technique. But I haven't tried it, so I can't say for certain, but that's my feeling. So, correct. Question. After McNally posted this video, I just want to ask a question about how it impacted how Proven was able to use its original marketing video. So what they're saying is basically, isn't it true that the original marketing video is now garbage? And then answer, what was the question again? The original marketing video, was Proven able to use this original marketing video after Mr. McNally posted this? Are you asking if Proven's video, question, remained active? And then, yeah, did it remain active? Answer, yes. This is not where the lawyer thought this was going. This is a sign that maybe they needed to prep their witness a little more. And because you want to know the answers, like you don't want to tell your witness what to say, but you certainly want to know what your witness is, going to testify to. You want to know what answers they're going to give. And the fact that the lawyer doesn't seem to know that they kept the video up is a problem. So question, what changes were made to the way that it was marketed to customers? That I'm not clear. Are you aware of whether or not comments were disabled as a result of Mr. McNally's And then they were, yes. Okay, do you know why? The nature of the comments were overly, I don't want to use the wrong term, but overly harassing. So how so? I don't want to misquote comments without re-reviewing comments, but to the tone of, these products don't work, these products are cheap. So, okay, now you have some experience with the lock and its interlocking core. Would you say that an average person would face even greater difficulty than you did in attempting to shim the lock after watching video 1? And in my opinion, yes. Here's the problem. I don't think an engineer has any special knowledge or special skills with respect to shimming a lock. I suspect that you can teach an engineer to shim a lock about as easily as a lawyer or, you know, a Starbucks barista or a meth addict who's looking to steal trailer hitches, right? Or trailers. So the he's saying, well, I'm an engineer. I've got all this knowledge, so I've got to be better at it. And I'm like, is it though? Somebody who's got a lot of practice shimming like Mr. McNally is probably ahead of the game, right? I believe Mr. McNally is extra special skilled, but I don't really believe that this engineer's skills really translate to anything for what he's doing here. That's my personal take, but yeah. So now they move on to video 2, and there is an objection because they're saying, hey, video 2 isn't yet in the case, and that objection comes up a bunch, but the judge is just like, listen, I'm going to let them bring in the other videos, so let's just get this over with, right? Let's get all of this information out, and then I can make a decision on the injunction with respect to all the videos instead of needing to come back and say, hey, now we need to decide about, yeah. The court's like, we're not doing that. So question, and you reviewed the part 2 video, is that correct? Correct, yes. Then what step-by-step explanations, if any, did the defendant provide about how to create a shim or how to fabricate a shim? So answer, in the second video was the process of obtaining shim material, approximate size and shape of the shim in the cutout present to bypass the lock. And then question, describe what's, as you perceive with your engineering background, what's special about that shim and what difficulties one would face from an engineering standpoint in recreating that shim. So answer, the position of the hook-shaped feature on the shim being specific to the depth of the locking plunger on the lock itself. Now, to my mind, and again, I'm not a super genius here, but you'll see here that there's a fair bit of kind of play on this, right? There's almost an inch of space here. So it seems to me if you can get to figuring out where that, where that plunger is to within an inch, it's okay if it sticks out into here when you're working. Like that's fine. That's not going to interrupt anything or stop anything. Really, the other thing is that when you've got a piece of, pop can in there, you can actually feel the position of this. You can feel that out and you can determine where that is by prodding it. So you can actually figure this out blind. I suspect, I don't know for certain, but I suspect that I could teach somebody from what I know without them ever seeing the video or ever seeing the inside of this thing, how to actually get into it. I don't know for certain, and frankly, I don't know that I have the time to figure that out, but yeah, maybe I'll find somebody and just see if we can do it. I'm going to a lawyer's conference next week. Maybe I'll see if I can figure out if I can put a lawyer to the test. Just some random lawyer. I don't know if I'll have time, but I will think about it. I also have to bring a really big camera setup. And I don't know if I want to carry that in my luggage. So I'll decide, but it might. We'll see. Okay. So they continue on. Can you discuss what in watching the video, Mr. McNally attempts to shims the lock without it being attached to anything? Describe how that would impact the perception of falsity, your perception of falsity. So how is it misleading or bogus, essentially, that they are shimming this lock when it's not attached to a trailer? So the answer is, so my impression is with the lock, we'll call it free in your hands, not attached to anything. It provides easier access to maneuver your hands around the product, to manipulate the product, to have a more comfortable feel and positioning of your hands. So basically, you can move your hands wherever you want, whereas when it's attached to a trailer hitch, you can't turn the lock. You know, it is the direction it's in, and, you know, you can't sort of occupy the same space as the trailer or the trailer hitch. Okay. Carrying on here to some further questions here. Would he have the ability to turn the lock and move it and manipulate it in the way that he's doing in the video in those screenshots right there? An answer, based on the trailer it's installed on, the lock can kind of rotate. Some trailers allow it to rotate like 90 degrees, kind of like swing like a hinge, so not freely maneuver as needed. And then question, now would you say that this video demonstrates a real world use of the lock? It does not. No. Okay, so, and then they run into some objections on asked and answered, but then we get to the court having some questions. And whenever I see in a transcript that the court has some questions, like the judge, this is always really something I'm going to latch on to, because that tells me what the judge is thinking, right? That's the only sort of ability I have to get into the judge's headspace and to figure out where they're at. So those questions can, not always, but they can be quite revealing. And in this case, they are. So here we go. So the court says, well, wouldn't anybody looking at that video know that it wasn't attached to a trailer? And the witness says, I would assume so, yes. And the judge asks, and he's not suggesting that it's attached to a trailer. And the witness says, correct, yes. And the judge, he's just holding it up in his hand to say, if I have this thing in my hand, I can open it by doing this. The witness, correct. And the judge, counsel, continue. What we see here is that the judge is kind of skeptical of the argument that, that the audience is fooled, right? Because the audience, when watching the video and they see him, pick up the lock and shim it, they can see there's no trailer attached, right? So they're obviously not coming to the conclusion that he's doing it with a trailer attached, because there's just no trailer attached. It's not like, it's, Wonder Woman's invisible trailer or something like that. The audience is not, you have to assume an audience of sort of ordinary, reasonable people, not like some special kind of moron that was bred into a lab to be only able to watch TikTok videos and maybe go into politics, right? This has got to be a person of ordinary intelligence, ordinary competence, who's making reasonable decisions about what they view. And the court certainly seems to think that Proven Industries' argument really requires that kind of special idiot. That's not a good place to be for Proven. Okay, so then they have a discussion here about a red dot and a green dot in the video, and they note that the red dot appears to indicate where the shim is attempting to be used. And then, so the incorrect spot for the shim, correct. And what does that demonstrate to you? And, I mean, that's a small margin, so one spot is right, one spot is incorrect. What does that mean to you as he's attempting to demonstrate that Proven doesn't know how to pick its own locks? An answer, to me, that indicates a certain knowledge level and skill set required to properly use those tools to bypass the locks. Now, I was able to figure it out. It wasn't hard. It was not difficult. And I'm just going to note here that many things in life have a small margin between correct and incorrect. Going back to Proven's own locks, that is the correct spot to open the lock. A quarter inch over, if you put the key into right there, it's never going to open, even with the correct key, right? If I am eating food, correct spot for food. Not correct, wrong, definitely wrong, right? This isn't like some special skill. I'm not like some super PhD at eating just because I'm able to do so within an inch margin. Come on, guys. I get that you got to argue what you got to argue, but Come on, guys. So based on your experience, how do you develop that knowledge and skill set? Would you have to disassemble the lock to know that? And the answer is you would need to examine the locking core. Depending on how the lock operates, it may be seen when the lock is open, or you may need to disassemble the lock to view it. You can also figure it out just by, like, poking the shim around. Like, you can figure out where that is just by poking. If you really wanted to get exact about it, you could, like, poke it in, see where the resistance is, draw a line on your shim, pull it out, and now you've got an exact measurement, right? You could do that. It's not hard. And then the judge says, and again, remember what I just said about judges' questions. So the judge comes in, well, I'm confused. When I'm trying to do something weird at home that I don't know how to do, I Google it and it pops a YouTube video and it shows me how to do it. And I follow the YouTube video to do what they're telling me to do. And eventually I'm able to do what they're telling me to do based on their knowledge and experience. I don't have to have their knowledge and experience first. I just mimic what they're doing. And so would a person who's trying to learn how to shim locks have to know what Mr. McNally knew, or would they just have to do what Mr. McNally did a couple or 3 times to mimic it? And that's exactly how I got into this lock, is just by mimicking Mr. McNally. I certainly do not have his level of experience or skill, right? I'm just not going to pretend at that, because if I do, like, nobody's going to take me seriously, right? He's obviously better at all of this. I'm actually demonstrably awful at it. So the witness says, I believe with some with enough skill development, you would see how it's done by someone more skilled in the art, and then through repetition, like you said, you would eventually develop that skill set yourself. And the court asks, but you don't have to open the lock and find out where the placement of the ball bearings or any of that. You could just watch what Mr. McNally did and just stick a piece of aluminum in the lock a couple of times, or 3 times, or 5 times, and you would put it in the place he told you to put it, and voila, the lock would open. And the witness has to duck and weave a little bit. Says, so the problem I personally faced, every unsuccessful attempt, the shim would break off inside the lock, and then I would need to use the key to open the lock and clear out all the debris. So after an unsuccessful attempt, you need the key present to kind of reset the slate to try again. Now, I tried to sort of play around with this a little bit. I've been playing around with it a little bit further, and I have had issues with, like, shims breaking. I'm told that there's some cans that are thicker. I don't know which ones they are, so I'm going to try to figure that out. Like, and I've done some preliminary research. Like, cans differ in thickness, so I'm going to try to find, like, a thicker, heavier duty can out there. I don't know where but I'll try a bunch of them. But one of the things I found is that, yes, that is a potential problem, right? It breaks off, it tears off, and so forth. But I have, through playing around, and some of this playing around I did after I read this transcript, often I can use, like, the shim to poke out, because if I get some stuff stuck because it tore off, typically I can sort of push it out and then it'll fall out. And so I don't necessarily know that you necessarily need to use the key to open the lock and clear out all the debris. It's helpful, certainly, but I don't know that it's necessary. That's just my pontificating. And he's saying that it's necessary. I can see why he'd say that, but yeah. And the court says, and this is a very reasonable question from the judge, right? But if I'm a thief and I'm invested in breaking into people's lock to take off their trailer hitches, I could buy one lock, practice a few times, figure out how to do it, and then if I want to go steal somebody's trailer, I would know how to do it because I would have practiced enough times with a legitimate lock, and I would just open the lock, subject to all this business about being able to access it because it's hooked to something. And the witness says, assuming the core of the lock is the same. And the judge says, but that's your number 1 or 2 selling lock on Amazon. And this is bad when the court is now arguing with your witness. Like, if I'm proven and I see that the judge is arguing with my witness, I'm like, oh, this is a bad day. Oh, I'm having a rough time. But the judge is right to argue here. The judge is right to ask these questions and to sort of inquire, because they're getting the sense that they're not really getting the full... They're sort of getting a smell to all of this, right? So the witness says, the lock body itself, yes. The actual little lock core, we call it, we have many different options available of different. Some are spring-loaded with a spring. Some are, it's called deadbolt style, so like a deadbolt on the front door of your house, so the thing comes out and you can't push it back in. You'd use the key to retract it. So depending on the lock core present in that lock body, so it sounds like that more secure one, the deadbolt style, is actually probably a good product. It's just that the spring-loaded one, not so much. The spring-loaded one is going to be vulnerable to shimming, and it sounds like the other one won't. So, I mean, if I'm Proven Industries, what I'm probably doing is saying, hey, you know what? We're going to take the spring-loaded one off the market. We're only going to sell the good one. And maybe if you really wanted to try to, do things, you might offer like consumers some sort of fix or maybe an upgrade. But I guess that would probably cost them a whole pile of money, because I'm guessing they've sold a whole bunch of these things and they really don't want to upgrade all those lock cores. So, and then the judge asks, which one is present in that one? The witness says, that one has the spring-loaded disc detainer core. And then the judge asks, and what percentage of your sales is that lock? And this is where they get a really, really bad answer. I don't have the exact numbers in front of me. I would say approximately 50%. And the judge says, so about half of your locks are the type he's demonstrating. Okay, so here's the thing. If you're trying to say, listen, he's deceptive because he's showing a crappy version of our locks, like the cheapo version, you want to show that it's like 5% of customers like do a downgrade to this like super crappy version, and we sell it, as like a cheapo option because some people want the cheapo option. You don't want to be like, this is half of our market. Yep. So the court has just kind of like sprayed fire on their argument here with some very, these questions to me indicate that as much as the judge may not have like perfect knowledge of shimming and all of this, the judge is 100% lasered in on the issues on this one. And that, I think, is a bad sign for Proven. Certainly that seems to go badly for Proven in all of these interactions. And somebody might say, oh, the judge is biased against Proven. No, I don't see any evidence of bias, because the judge does give grief to both sides. The judge just doesn't have a whole lot of patience for BS, and one side seems to be bringing more BS to the table than the other. So, all right, question. Okay, and how long of a process did it take you to eventually, get the lock open with your training and experience and knowledge about these locks? And then answer. So eventually, to make the shim and open the lock, approximately 30 seconds, 45 seconds. Then, okay, after you'd figured, how many failed attempts did you have? Approximately 20 or so. And then they note that that was when the lock isn't attached to anything. All right, and he was not able to open it when it was attached to something, trying a dozen times. This is still really bad, and especially like 30 to 45 seconds. I think that eventually they're going to get a, and if I'm a thief looking to steal these things, I am not making the shim on site, right? I'm not sitting there standing by this trailer that I'm looking to break into going, you're not sitting there like shotgunning the your can of whatever. You're probably walking up with a shim already made, probably one you've used before, like one that actually you might even have one that's made out of stronger material, better material than, this, and you just have it like tucked into a pocket because it's super concealable. It's just a flat piece of metal that doesn't look like anything. And, if it takes you 30 to 45 seconds to get into it, again, that's him saying that it's, in a hand, as opposed to he's saying I couldn't do it on the trailer hitch. But like that's including the time to make the shiv, right? So that's got to be just seconds to actually do it. The other problem with all of this is that let's just imagine you're the nosy neighbor, right? You are, you're the neighborhood watch, unofficial, unelected, unsanctioned. You're the person who's on Facebook posting like, I saw a sketchy guy with, a shopping cart full of cans. Everybody be aware. And you see somebody roll up to a trailer. And if you see them roll up to a trailer and like break out a crowbar and start going, you're probably getting on the phone to the cops right away, right? If you see them break, a sledgehammer, a angle grinder, thermal lance, any of these things, you're probably getting on the phone to the cops to say, "Hey, I'm seeing a crime in progress." But what you probably aren't, you're probably not thinking crime if you see a guy walk up to the trailer hitch lock, pull something out of his pocket, do a thing, and the thing unlocks. You're probably thinking, "Oh, that guy's got the keys." And if you're thinking, "Oh, that guy's got the keys," you're probably thinking he's allowed to take this trailer. That's legit. That's allowed. This is another problem with the shimming attack, as opposed to like somebody being able to break something into it, is that it's a really big problem when it happens, because somebody observing it might have no clue that it's actually an attack in progress, right? No lock and no security system is perfectly secure. For my guns, I've got, cameras and motion sensors and, all of the sensors, right? And there's a safe. And I don't think that my safe will last forever. I don't think that somebody is just going to be unable to get into a safe, because I do criminal defense. I know they can, right? I know that they can eventually get into a safe. But what I'm hoping that my safe can do is stall them for, let's say 20 minutes, long enough for my security to get help there, the police or me or whoever. And then the police, can intercede and prevent the theft, right? Because that safe stopped them. But you also need the detection. And shim-based attacks tend to also defeat the detection, because you can do a shimming attack in full view, right? You could have a crowd of people. You could have a full-on freaking parade walking by the trailer, and if somebody just shims it, it's virtually certain that no one's going to notice that there's a theft going on, and nobody is going to complain unless they happen to specifically know that trailer isn't supposed to go anywhere, right? Okay, now, Proven has some further problems with Mr. Sansone, and we'll get into those. So, by Mr. Turkle. So this is in a voir dire about his qualifications to testify as to certain things. And then question, you don't work at Prudent, right? Answer, I do, yes. And then question, you don't work at a company called Dynamic Manufacturing? You're not a VP of Dynamic Manufacturing? And he says, I am, yes. All right. That's who, when you get a paycheck, it comes from Dynamic Manufacturing. I say the paycheck comes from Proven. So here's the problem. He's got two employers listed, Proven and Dynamic, and it does not become entirely clear as to who he works for and how and so forth. So the judge asks, well, the question pending is Proven an employer of yours, or do they just pay your paycheck? What's the answer to that question? And the witness says, I believe an employer. The court says, you believe you're employed by both Proven and Dynamic? And the witness is correct. I believe I serve roles for both companies. And that is possible, right? You can have two jobs. And Mr. Turkle says, asks any particular reason why you didn't list Proven as your employer, your current employer on LinkedIn? The answer is no particular reason, no. There are some further, sort of questions here. And there's some issues as to redactions. And they're trying to tender redacted documents in this proceeding. And we're going to get to some discussion about sealing, because I already talked about how Proven screwed up about the sealing stuff. But Ms. Ellis says, I just want to indicate, Your Honor, that it was redacted to preserve the privacy of those individuals, because there were a lot of threats that were going to each of the employees. And so every employee that was identified by Proven were receiving, and we do have some exhibits to demonstrate it, threatening messages to their email addresses. And notwithstanding that, Proven decided to put their founder's girlfriend's name into a filing. I don't understand this whatsoever, but they did. But the court says, well, we're here on the point of whether this document can be admitted into evidence or whether it is impermissible hearsay. And you're trying to introduce it as a business record, saying it's in the manner in which it's kept in the ordinary course of business. And it's the ordinary course of business to keep it in this fashion. And that's not accurate to this document because it's been modified for litigation. So it is not a document kept in the ordinary course of business in the manner in which it is kept. It's a separate pulled out document. So it can't be introduced as a business record, and it is offered to prove the truth of it, the matter asserted, which is why the customer returned the lock, and that's hearsay. So it's hearsay, and so it cannot be admitted. So here's the problem. They want to tender hearsay, and hearsay is any out-of-court statement that is used to prove the truth of its contents. And so a sort of good test for that is, would it matter if you knew that the person making the statement was a liar or not? You know, that's sort of a good ballpark test for that. But they're trying to use an exception, the business records exception. And that exception exists because we have businesses now that keep tons of records, and it's often a really big pain in the butt for a business to actually bring in like the actual person who took the customer service call. And so courts will allow people to bring in something that is a business record, but it has to be an original business record. The instant it becomes a different document, it's a document that was prepared for litigation, then it can't be introduced. And so here, the issue is, hey, this is no longer a business record. You redacted it. It's now a document that you prepared specifically for the litigation. One of the reasons why business records are typically allowed is because they're considered to be reliable, because they're made in the ordinary course of business and not in expectation of litigation, right? They were made when nobody knew a lawsuit was coming, and so nobody had any reason to lie. This is just documents we keep all the time. So Ms. Ellis for Proven says business records are often redacted to preserve confidentiality of parties, to remove personal identification information. You know, the witness has testified to how the record is maintained, how it was escalated to him, to how he viewed it. We understand that it's been redacted for purposes of litigation, but it's not uncommon that business records are redacted for that purpose. And the judge says, do you have the unredacted version in your possession? And they say, it's on that laptop. I can, Your Honor, it's on that laptop. I can access it. And then the court knows how sealing works. The court says, I need to see the unredacted version. And if it needs to be sealed to protect the identity of the people, then let's seal it to protect their identity. But for purposes of a business record, it has to be a business record. Like, we can seal this, right? You can file things under seal. You can make an application to file things with redactions. You can make all of these applications, but you have to actually do it. I just kind of find this funny because I just look at the whole, like, you know, we need to file stuff under seal, and they just mangled it really badly. All right, so they're going to continue on, and the judge is going to have questions herself. So the judge says, or do you only have a role as vice president of Dynamic? And answer, by title, vice president of manufacturing, but as the company has grown, I've expanded roles into helping with the rules of Proven as well. And the judge asks, do you have a title within Proven? If we could look at their org chart, where would you appear? Ooh. The judge is a scalpel throughout these, these proceedings. And they say, under the org chart of Proven, I would not. There's a vacant spot for vice president at Proven, so I'm helping to fill those roles until we're able to officially seat someone in that position. The judge asks, so you're not on the official org chart of Proven in any capacity? Witnesses, not currently officially, no. Court, so your role is in Dynamic? And then the witnesses, according to the current org chart, yes. So that issue does not go well for Proven, and the judge does actually give Proven a bit of wiggle room here. Weasel room. The court says, do you have, and this is to Proven's counsel, do you have some other records custodian you want to introduce these documents through who actually works for Proven on an org chart, whose job it is to maintain the custody of Proven's records? And their counsel says, give me a moment, Your Honor. The court says, yes. And counsel says, yes, Your Honor, we do. And then the court says, all right. Then the court sustains the objection. I don't believe that Mr. Sansone has adequately demonstrated to the court that he knows anything about the maintenance of records in a way that gives the court comfort that it can rely on this document, which is, rife with hearsay, as a business record without someone telling me how it's kept in the ordinary course of business. And if there's such a person, I'd like to hear from that person. So the court says, listen, do you have another way to get this document in? And they say, yes, we do. And the court says, great. Then I'm keeping this document out until you bring that person in. And spoiler alert, that document does not go in. They never actually get to that. All right, so now we are an hour deep, and that is kind of how I roll on these videos. I am sorry. I've had some comments about like, why are your videos so long? Well, because I'm thorough. And we're just now getting to cross-examination. And yeah, it's actually kind of funny how cross-examination begins, at least from the perspective of a lawyer. I know not everyone's going to think it's funny, but I will. So, and maybe like 4 of you will. So we're going to show it. So Ms. Ellis says, yes, Your Honor, we can actually release this witness. I can follow up my questions at the end with my other witness. And the judge says, well, he has an opportunity, as in the other side, to cross him. They're like, this witness can go, they can leave, they can go home now. And the judge is like, or we can just go to cross-examination, because cross-examination is a thing that happens in courts. So, yeah. So cross-examination begins. And they say, question, there was a lot of discussion about your efforts to shim the lock that's in part 1 in the part 1 video. The bottom line is, though, that after you said 20 attempts, you were able to do it, right? Then answer, after watching the other videos, yes. Right, and you watched a how to do it video, and then you replicated it, and it maybe took you a few times, but you could do it, right? Eventually, yes. All right, and so one truth we know is that with a shim made from a tinfoil can, you can trip that latch and release the lock, right? Bypass it, as you say, right? Correct. Yes. Okay, that's already an incredibly damaging admission, but he already made it on direct, but reinforce it on cross. Absolutely. Question, have you ever gone on YouTube, like, to figure out how to do something to your car or your house? Answer, yes. Question, all right. When you see a car mechanic explain how to do something with a car, do you assume that's the first time they're trying it? Answer, I don't assume that, no. Question, right, you assume they know what they're doing, and they're showing others how to do it, right? Answer, yes, I would hope so. Now, here's the thing. I am not a skilled car mechanic. If I made a video about, here, let me demonstrate me fixing a car, I can tell you that some people would watch it, but they would not watch it in order to be like, hey, we're going to learn how to fix a car today. They would probably watch it in terms of like, hey, isn't this hilarious? This white-haired weirdo is doing the dumbest things and is probably causing permanent damage to his vehicle and, maybe also himself, right? When you go on YouTube to watch somebody do something, you probably assume that they've done it before, unless they say otherwise, right? I watch people who go and do a bunch of, shooting stuff, and I don't assume it's the first time they've handled a gun. It's an excellent point, right? That the average viewer on YouTube is not going to assume that this is the first time anybody, that Mr. McNally has done this. And in fact, if they were making that assumption, it's easily rebutted by just like clicking the all videos by this poster thing, right? Okay. So, then question, after you successfully shimmed it, did you go back to the owner, Mr. Ron Lee, or to Chris Canning, or to anybody and say, hey, we should probably take that video down, because when he tells everybody we've never had anyone tell us this can be done, it's not true. I did it last night. Answer, I did not suggest to take that video down. Then question, well, I mean, but wait, he's not telling the truth, is he? Answer, I believe what he said in the video is we've never had a customer complaint that their lock was shimmed off. So question, I think he said more things than customer, but my point is this. As we sit here today, we know that it can be shimmed, right? Popped out with a shim, right? Correct. And so his point here is that they have a video saying, hey, these things are shim resistant. And he's like, you know that's not true because you can shim it, right? And he's like, yes. I think this goes a long way to establishing the sort of public interest aspects of Mr. McNally's commentary because, as an idiot who is looking to buy a lock, I don't know how to test the security of this thing. I mean, I can guess and so forth, but I look to experts to tell me, right? And maybe I don't look to the companies because the companies themselves don't necessarily have the interest. And this isn't just a proven thing. This is every company, right? If I ask a company, hey, um, is this a good battery? Well, the company's going to be like, yes, we are the best batteries ever. And, in practice, maybe it is, maybe it isn't, right? I want to know from people who, like, maybe use batteries a lot, maybe are critical. Like, hey, do you think this is a good one? If I'm going to a restaurant, I probably look at critics' reviews of the restaurant rather than just, or customer reviews rather than just does the restaurant say they're delicious. Okay, carrying on. So, and then they've got, a video there and they stop. This is probably the first video they note. Up at the top is a post from the Proven Locks Instagram account. Do you see that? Answer, I do see it. Yes. Question. All right. Now it says, sorry, but McNally has been fooling people for years. He makes and edits his videos to make himself look good. The lock was altered, and we currently have a lawsuit against him for the lies he has made. He will be exposed in court with a jury to decide. That's how confident we feel. I actually feel like Proven is setting themselves up for a counterclaim because Mr. McNally has like hojillions of subscribers across all these platforms. That's Proven's argument, right? And they're sitting here and his business, right? The reason why people watch him is because he does, he shows his skills. And if they're saying that he fakes his skills, then they are directly attacking his ability to generate income through that. And I'm going to guess that he's probably generating like buckets of income. He probably can buy a dump truck with his income and fill it with money. And, you're saying that all of that is fake? Like, Proven, you should really think about whether or not you are more at legal risk than they are. And quite frankly, I think Mr. McNally is being a stand-up guy, not filing a counterclaim. But that's yet. We might actually see a counterclaim coming. I don't know. Certainly, if I was Mr. McNally, I would be thinking about it. And I'm guessing they're having those conversations. Yeah. All right. Carrying on here. Now, was this video, let me rephrase that. Was that post sent out after the canning video, Exhibit 16 that we just saw? Answer, I'm not sure of the timing. Question, did you read that post before it went out? Answer, no. Question, do they run any of the technical language in these posts by you as the mechanical engineer who knows locks? Answer, no. Question, do you know of any facts that support Proven Lock's statement in this segment of Exhibit 17? Do you know of any facts that support the company's statement that the lock was altered? Answer, no. To me, it seems like opinion. Whoa. So for defamation, you can only sue for defamatory statements that connect to some like actual fact, right? So as an example, let's say I go to my local restaurant and I say, I post a review and I say, this food was poison. They probably can't sue over that because the average person would interpret that as me being hyperbolic to say that the food was really bad, right? They're probably not going to be able to successfully sue for defamation. But if I then, instead of just saying this food was poison, if I instead get real specific and I say, this food was poisoned, they put lead in my food, I suffered the following, I suffered organ failure, I needed to get a new, kidney and appendix and, yeah. Now I could be into defamatory, language, assuming it wasn't true, because, this is now establishing a fact. Now, when they're saying, do you know of any facts that support Proven Locke's statement in this segment? He's like, it seems like opinion. And I'm going, wait, you say that he makes and edits his videos to make himself look good? Okay, maybe that could be an opinion. Maybe that's not specific to anything. The lock was altered and we currently have a lawsuit against him for the lies he made. That would be a specific statement of fact, right? That is very specific. I'm just saying, Proven needs to make some serious decisions about whether or not all of this is a good idea. And I mean, this is part of why I think McNally's team wants to get into this stuff, is that they're getting some great admissions out of Proven's team. So, all right, carrying on here. They say, now, was this video, let me rephrase that, was that post sent out after the canning video, Exhibit 16 that we just saw? Answer, I'm not sure of the timing. Question, did you read that post before it went out? Answer, no. Do they run any of the technical language in these posts by you as the mechanical engineer who knows locks? No. Do you know of any facts that support Proven Locks' statement in this segment of Exhibit 17? Do you know of any facts that support the company's statement that the lock was altered? No. To me, it seems like opinion. Yeah, I don't think it... I mean, parts of it, yes. I think parts of it are potentially actionable. So, like opinion, right? Like they're pushing back at some critic, right? To me is how it seemed. Yes. Robust discourse. Free market capitalism, right? Right? Answer, I don't quite understand the question. Question, well, when people go to restaurants, if they don't like them, do they go on Yelp and say, I didn't like the restaurant? Answer, people do, right. Right. There are people who are paid to review restaurants also, correct? I believe so, yes. I mean, I assume you haven't been living under a rock, but okay. We can apply that to cars, right? I believe so, yes. Any number of consumer products that are subject to parody or critique, etc., correct. I believe so, yes. In fact, in Exhibit 16, the one with Mr. Canning in it, he kind of lays down the challenge. And I think he says, we're throwing down the gauntlet. Let's get down to business. And he says, this is why McNally is wrong, right? And then there's an objection. Mischaracterizing the video. Court overruled. So, question. Against the background of this video where Proven Locks is basically calling him a liar, saying he's been fooling people for years and claims the lock was altered in the very first video he did, and that they currently have a lawsuit talking about this lawsuit, right? I believe so, yes. All right. And then the Proven is like, objection, this witness doesn't have personal knowledge of that post. Court overruled. I think Proven may be giving as good as they get online. Well, not really, they're losing that battle, but they're trying. And because Proven is throwing some punches here and calling McNally a liar, they're really undermining their own position. There's a reason why your lawyer will often tell you, shut up when you're in litigation. And the court's going to give McNally a bit of a shut up warning, too. We're going to see that. So, the word I kept hearing during your testimony was, it was your opinion that it was misleading as to the size and shape of the shim, right? Correct. Question, he cuts the shim on camera, does he not? Correct, yes. You don't see him measure anything, do you? No, you do not see him measuring. Maybe he had a lot of experience at cutting shims and it comes easier to him, right? Yes. So, yeah. They're like, you don't see him with calipers or anything getting an exact thing, right? It's just kind of, he does it by feel. Yep, okay, great. That's undermining their claims pretty badly. Question. Well, your declaration in this case, complaint in general, frames this as these videos appear to be defamatory and false because they imply that anybody can do this in one try with any number of household items, right? To that effect, yes. Yeah, you signed the declaration. You remember that part, right? Yes. If a lawyer's ever asking you if you signed something or if something was under oath, you should be really nervous because typically it means that they're winding back a punch. So, okay, now nowhere on these videos does Mr. McNally ever make a statement that you can do this in one try with any household item, does he? I don't believe so, no. No, so that's just what you decided when you saw the videos, right? My interpretation of it, yes. Okay, well, I mean, somebody else may have a very different interpretation. Carrying on, and I'm sort of skipping a whole bunch here. So, like, when I'm cutting, I'm skipping through a whole bunch. Sometimes I show myself scrolling just so you can see how much, but I'm like, I got to decide what I'm doing there. So, question. You think he was obligated when he was done bypassing that lock to say, but that type of shim only works on this lock, so I'm not representing it works on another 1,000 out in the market by every other manufacturer? Answer. I believe a fair and honest review would have provided that information. Say that in front of a jury. If I'm McNally's lawyers, I want you to say that word for word in front of a jury, because it's just gonna seem petty and weaselly, and they're gonna be like rolling their eyes super hard because they've never seen that in their life in any review, right? Like, you know, let's say I go to a restaurant and I say, I had the burger and fries and it was the worst burger I ever had. You know, I would be happier eating rat than having another one of these things again. You know, I don't need to post that I also didn't try their milkshake and that I didn't try their steak and that I didn't try their, you know, filet mignon. And yeah, I also don't need to note that I didn't try like you know, my review doesn't apply to like some other restaurant entirely. There's only so many disclaimers that are sort of reasonably necessary. Um, Question would have added that my information is only limited to the product I'm reviewing. Answer. Not proven locks in general. Correct. Does he make any statement at any point that states that this is limited or not limited? Does he make any statement beyond what he does to the actual lock is probably the better question. Answer. So what's the question? Does he make a statement? That's fair. There was a lot of question in that question, like several questions. Sure. Does he make any statement that what he's doing is applicable to every other lock made by Proven or anybody? Answer. I don't recall everything that was mentioned in all the videos. I don't want to state. Question. What car do you drive? Answer. It's a Dodge pickup truck. Question. If you want to fix something on a Ram and you pull up a YouTube video, do you expect the guy to say, this isn't going to work on a Ford or a Chevy? And Proven's lawyer. Objection, Your Honor. It's an improper analogy. Court. Overruled. Do you? Answer. If I was pulling up the video for something specific to my truck, right, it would be irrelevant. Exactly. When he's showing that he can get into one lock, it is kind of irrelevant to say, and there are hundreds of other locks out there. Question. All right. Another point you discussed was it was misleading because he didn't mention that it would be harder to do depending on what it was attached to, right? Something about that, like a trailer. You may have made more than one reference to it, but do you remember that general discretion? Answer. I believe he does mention it. He does, right? I was about to say that in one of the videos he says it could be harder depending on what it's attached to, right? Yeah, the video we just clicked. Right, but you've testified to the fact, you've testified a number of times that it's misleading because you have to be able to freely manipulate it in your hand, right? Correct. We can agree that Mr. McNally actually says that in one of the videos, right? He does, yes. And it would be obvious to a viewer, would it not, that he's only manipulating it with his hands? Let me try it this way. A common viewer, right, looking at that video, any of these videos, can tell the difference as to whether the lock is being manipulated in his hands or if it's attached to a door or a boat or a trailer or whatever, right? Answer. That's where it's a little difficult for us based on the feedback or even into our customer service platform of to the effect of these locks are ineffective. This is... McNally's team has clearly, either they planned this out ahead of time because they knew that this was a fruitful angle of attack, or they were listening to the judge, right? And when the judge is like, hey, I'm going to start digging my teeth in on this particular issue, you're like, yes, you are, judge. Let's, if the judge is gripping onto someone's leg like, a dog, attack, you're just sitting there going, okay, well, that's exactly where I want to sprinkle the barbecue sauce and just let the judge go to town. Like that, if the judge is seeing a weakness, you just want to poke that. And that's exactly what they're doing there. So, question, and I skipped over a bunch again. And he's not making statements that proven as identified in a pleading or a court document that, and by the way, I'm only holding it in my hands, but this is just as easy if it's attached to a trailer, right? He didn't say that. Answer, I don't believe he says it, but based on, again, the feedback we're receiving to customer service, that's how it's being perceived. Here's the problem. The feedback you get from customer service is going to be the angriest jerkbags. And those are the least reasonable people. Your jury is going to be full of people who are actually like sensible and, you know, can wipe their butt without like help and a YouTube video and an assistant. And you kind of need them not to be that. And that's a bad thing for your case. So, question, the only feedback I've seen in this one document that we spent 30 minutes on earlier, I haven't seen all the feedback, but it would be true that the feedback related to the fact that people paid $130 for a lock that you can open with aluminum. Answer, when held in your hand, yes. All right, and did he do any other exemplars other than that? Answer, the first video was installed on a trailer. Question, on a trailer, transparent for the eye to see, correct? Correct, right? You can tell that there's a trailer there. It's not like it's an invisible trailer. And yes. Now here's the question I've been asking a whole lot in my videos, and he actually gets to ask it. Question, when you did it yourself, did it occur to you for one moment that maybe the best thing to do instead of file a lawsuit was to fix it? And their lawyer, objection, Your Honor. And McNally's lawyer says, I think it's a fair question, Judge. And the judge says, well, I don't understand what the objection is. Ms. Ellis, Proven's counsel, I mean, again, the court, relevance? And Ms. Ellis for Proven says, relevance. And the court says, hearsay? What is the objection? Ms. Ellis says, relevance, Your Honor. The court, overruled. Nope, it's relevant. Go on. The court and the witness asks, what's the question? The judge says, did it ever occur to you that the solution, rather than filing a lawsuit, would be to fix the lock so you can't shim it with a piece of aluminum foil? And the answer, Proven is taking steps to rectify some of the issues with inserting shims. Great. This is what they should have done from the outset and not filed the lawsuit. Proven, like, serious. These kinds of cases make me feel like I should like set up a side business consulting for like, so you think, some influencer is mouthing off about your product. What should you do? And I would probably just have like a big sign that lights up with a button, if somebody's sitting in my office and just that says, do not sue them. And then I could put the button and hit the button. It would just light up, because that would be my advice so often that I would just reach over and hit the button and point. Yeah. I mean, some of these things, I feel like the whole like YouTube-y influencer whatever world is hard, right? It's not easy at all, but I feel like some people make it a lot harder than it has to be, because it's really hard to get like the best possible answer, but it's really easy to avoid the sea of shitty answers that so many of these people seem to find. And Proven, like, not only seems to have quested for the sea of shitty answers, but they're like building a deep sea diving rig to find the shittiest possible answer in the darkest depths of the sea of shitty answers. To like, they're going to bring up the Cthulhu of shitty answers here. Come on, like, guys, you can still fix this. You can still fix this. I'm astounded at this. And quite frankly, if I'm Proven's team and I'm looking at the answers their experts, their witnesses gave in this proceeding, I am probably going, I don't want to take this to a trial. This is a bad idea. Like, in the same way that if you take a car for a test drive and the bumper falls off and it catches fire and the car somehow manages to form an arm to flip off a cop, you would probably say, I don't think this car is the one to take on a road trip. Okay. All right. I'm just going to say this is the kind of stuff that keeps lawyers in business, which is clients making bad decisions. Yeah. And this, I mean, maybe they'll win. There's always a possibility. But this looks to me at this stage like all sorts of bad decisions from beginning to end. So, question, has Proven taken down any evidence? Has Proven taken down any of its social media posts calling Mr. McNally a liar, a deceiver, whatever words they use, since you discovered that you could shim the lock with a piece of aluminum? Answer, I believe a majority of the comments have been removed that were... Question, well, y'all removed a lot of comments. I get that. I'm talking about whether you removed posts about him, like the one we just looked at in Exhibit 18, calling him someone who had been fooling people for years and all that. Answer, I believe that was a comment that's since been removed. Good move. Excellent. Fantastic. Carrying on to question. Let me ask it differently. Mr. Canning's videos are meant to promote Proven's products, right? Answer, right. All of the videos we've seen of Mr. McNally were meant to critique Proven Locks' products, right? Correct. They're not doing videos for the same purpose, are they? Under those, and then Ms. Ellis's objection, Your Honor, again, speculation, overruled. They say, I was going to say, just as you described it, no. So this is a critical thing, and we can look at cases like Hasinzada, versus Klein. I've also been covering some of Ethan Klein's latest stuff, but one of the critical issues is, do you transform the purpose of something? So as an example, let's say, I'm just going to reach out and grab a book here. I'm going to grab a book that I guess is, well, here. This is an old book, but okay, it still works. A D&D book, Complete Shire's Handbook from Al-Qadim. Okay, so it's got a whole bunch of stuff basically teaching you how in 2nd edition to play certain... Yeah, that did not land on the shelf, but certain varieties of wizard, basically. Okay, cool. So it's intended for the purpose of teaching you how to play this role-playing game. Well, let's say I think the book sucks. Right? Let's say I think this book is awful. And so I do a lengthy critique where I say this book is awful. And I borrow some bits from the book just to illustrate how awful it is, right? Say a few paragraphs. Well, my purpose is very different from their purpose. Their purpose is to be something you'd buy to play a role-playing game. My purpose is something to basically say, don't buy this, it's awful. And so that's very helpful for, when you're looking at the fair use factors. That's a very helpful thing to have that transformative purpose. But we can think of other things. Let's say I take the text. Let's say I take the entire text out of that. And I cut it into ribbons with like a ribbon shredder. So now you can't read the text because I've cut it vertically and like each character is on a separate... And I use it to make a sculpture, right? I make a pigeon out of it. And maybe I have some artistic reason for using that book in particular, but, I make a pigeon. Well, it's obviously not in the same market because, and it's not the same purpose because the original purpose is a role-playing game book and the new purpose is a pigeon sculpture. So that kind of transformative thing is very helpful for fair use arguments. Similarly, another aspect is competition within the market. So as an example, let's say I take, and I guess it's a good thing it didn't make it onto the shelf. So let's say I take this and I pull out a whole bunch of sort of what I think are the best bits. And I make them into a guide for like a role-playing game book, but maybe for like a different game, right? This is for D&D 2nd edition. Maybe I make it for like Vampire the Masquerade or something. Well, now we're still in the same market. We're potentially competing. Somebody buys my book to allow them to play those things in the, the vampire setting, not So all of, these questions that they're asking get to both transformative and to not competing in the market. It's not indirect competition, right? Okay. So that's why the lawyer's going there, and they're getting some great answers for it. So we know Mr. Canning. You've told us that Mr. Canning was hired to do the videos, produce them with Proven's direction, right? Correct. And they're promotional. He's promoting the locks, right? Correct. Okay, Mr. McNally isn't promoting Proven Locks, is he? Not yet. Definitely not. No, not yet. That may be the best point of the day, but what he's doing is essentially showing how they fail, right? Correct. Those particular locks. If Proven is smart, they should be grasping, like that not yet should be some serious foreshadowing, because they have all the possibility of a happy ending here. The happy ending is hire McNally to fix your locks, do a big presentation, and hire McNally to promote your locks, right? Have him say, hey, I found these locks. They were they were bad. And with my help, they fixed them. Now, I'm going to give an example, and I'm going to give an example here that is, I'm going to give some full disclosure here, and I'm going to talk about how this example is not in my financial interests. There's a company called Vaultec. Vaultec makes little pistol safes, biometric pistol safes. They're great. I encountered them at SHOT Show, and I was like, I would love to do videos talking about how great your products are. And they were like, that sounds awesome. And then they ghosted me. I have not been able to get an answer out of... They said, hey, we'll give you a final answer. And I have not been able to get an answer out of them for months and months and months. But the reason why I wanted to work with them is not because they were going to pay me or send me free stuff, although that's nice. The reason why I wanted to work with them is that I actually liked their products. And one of the things I liked about their products is that at one point, Lockpicking Lawyer did a video, and he's like, there is a fundamental problem with this, one of their products. Look at how I can defeat it. And you know what their answer was? Well, they didn't sue Lockpicking Lawyer, that's for sure. They actually went and said, hey, you know what? Thank you for identifying this problem. We're going to work on a fix. We're going to work on rolling that fix out to existing customers. We want our products to be secure, and we appreciate that somebody managed to identify a flaw in it that we hadn't seen, and they went and fixed it. So, like, I'm sort of cutting my own throat in the sense of like, hey, I want to work with these guys, and then they don't answer me, and I'm still promoting their product here. But I'm promoting it because I think it's a good thing. And it's such a big example in comparison here. Proven had the opportunity. I'm sure that if they reached out to McNally and just were like, hey, it's not hard to do the right thing. And it's not hard to, a lot of these guys are not hard to work with. And ultimately, I mean, if they just... Let's say McNally is rude to them. Let's say they reach out to McNally and are like, hey, we want to do some stuff with you. We want to do a thank you for getting into it. We want to give you our new version and see, is this more secure? And, let's say he's like, F you, I hate you guys, whatever. You can still win this, like do an improvement just by going, hey, we've made a new lock. And if it's secure, then you don't get if you assume that McNally is the biggest jerk on the planet, and that's not what I'm assuming, but we're dealing with a hypothetical here. If you assume he's the biggest jerk on the planet and he's just out to destroy Proven's products, well, you put out the new product. You're like, we fixed this shimming problem. And either he comes out with like, hey, I can still open it with a pop can, in which case you got to fix another problem, or he just doesn't. And this is one of those areas where like somebody's silence, you don't need to provoke them. You don't need to like say, look, he hasn't made a video, but just somebody's silence would be a big answer, right? I don't get it, but so you can see sort of the correct approach versus the incorrect approach. And correct, Vaultec. Proven incorrect. Like, I feel like I should just write a book on this and just be like, so your product is being made fun of online. How do we solve this? Yeah. So Mr. Turkle, okay, Judge, if we could have a moment to confer. Yes, Judge, we're not going to call witnesses. And I don't want to disappoint anybody. I don't want to disappoint everybody. Since they're relying on Mr. Lee's declaration, Your Honor, he's got 3 felony convictions. We have certified judgments. So when they say we're not going to call witnesses and I don't want to disappoint everybody, they're like, Mr. McNally, we don't think we need him. He can stay in his chair. We're not doing the demo because we don't think they brought their case. And spoiler alert, Proven is right on that. Or sorry, McNally is right on that. Proven is wrong. So they're like, yeah, if they actually called Mr. Lee to the stand, we'd be able to confront him with his felony convictions. So we're just going to say, well, because they're just putting in his declaration, we get to put in his felony convictions. Under 815, essentially a hearsay declarant could be impeached the same way as if they were in court. The court says, do you have those? They say, yes, Judge, they're on our exhibit list, and I was just going to offer those with the understanding, Judge, that, and the court says, just the convictions themselves, not the nature of them. And Mr. Turkle says, it's the judgment sent certified with the public record seal from Pinellas County and Manatee, I think. It didn't have the sentence on it, which usually surprised me because judgment and sentence come together, but the court says, 1 second. Does the plaintiff disagree that the declarant has 3 felony convictions? And Ms. Ellis says, no, we do not disagree. So the judge says, the court will accept that as a fact without the introduction of the exhibit to the extent that the exhibit might disclose the nature of those convictions, which isn't relevant to the court's consideration of the fact that he's a felon, unless those documents establish that the crimes were for crimes involving truth and falsity. Are they? So you might be saying, what are they saying here? Well, when the court's like deciding about how somebody is going to be as a witness, maybe it isn't the most relevant thing that they committed an assault or a bank robbery or, even that they carved somebody up with a chainsaw, right? That doesn't necessarily tell you that they're truthful or not. But if they have like 15 perjury convictions, then you're probably not going to put a whole lot of weight on the stuff they say under oath because they do perjury like it's tennis, right? And I don't even play that much tennis. If you've got somebody who just regularly or even once commits perjury, that's a big deal. So Ms. Ellis, for Proven, says, they are not, Your Honor. So they're not crimes involving truth or falsity. And that turns out to last for about 4 seconds because Mr. McNally's counsel says, one of them, Judge, would be a crime that would go to the character trait of honesty, veracity, yes. And the court says, what's the crime? The answer is witness tampering. Felony witness tampering. And the court asks the Proven's lawyer, that would go to the veracity and truth of the declarant. Would you agree, Ms. Ellis? Ms. Ellis says, yes, Your Honor. Court, all right. So he has 1 felony for felony witness tampering and 2 other felonies of a different character and type, but felonies nonetheless. So let's talk about the wisdom of going to trial in a case where your lead of your company has a conviction for felony witness tampering. Because you better believe that's going to come in. You better believe they're going to put that in. And then doesn't that end up making the jury, like this goes to a jury eventually if they take this to a full trial, perhaps, might go to a judge, but probably going to go to a jury. Do you think the jury might be going, oh, well, this guy tampered with witnesses before. What do we think of his witnesses today? Like, do we think his witnesses are good, or do we think that they might have been tampered again? This is one of those things that you got to think real hard about when you're deciding, hey, do I want to go and bring a case? This transcript is highly illuminating in terms of, like, my thoughts on whether or not I would want to be Proven's lawyers right now. And I will just say there are places I would rather be, and some of them are like the trunk of a car. So the court, all right, actually that's not true. Proven's lawyers are probably getting paid just fine, and they'll go in, they'll do their best, and they'll have another day, right? All right, the court has heard all of the argument, and I've read all of these affidavits and declarations and the cases the parties have cited. I've reviewed their motions and responses and replies, and I've heard what evidence was offered through the testimony of Mr. Sansone this morning, the only witness called by the plaintiff, and the court declines to grant the preliminary injunction motion. Now, it's hard to get a preliminary injunction, so the test is really high. That's not to say that some of this stuff can't be proven in a full-blown trial after full development of the record and discovery, but the extraordinary remedy of preliminary injunction presumes, of course, certain substantial factors that have not been satisfied here. Principally, the proof of a likelihood of success on the merits of the motion, based on the preliminary demonstration made at this hearing. This is a high burden to meet, as you know, and I don't believe it's been satisfied on this record, i.e., the court is like, you are losing on the merits aspect at this stage with the high burden of proof. But you haven't shown me merit yet, is what the court is noting. In regard to the copyright claim, which is the first claim that was pursued on the motion for preliminary injunction, the court is to consider a number of factors. The ones that sort of floated to the top of the factors for consideration are the purpose and character of the work that is claimed to be infringing, the nature of the copyrighted work that is claimed to be infringed upon, the amount of substantiality of the portion used in relation to the copyrighted work as a whole, and the effect of the use upon the market for the copyrighted work. The court finds that the purpose and character of the use to which Mr. McNally put the alleged infringing work is transformative, artistic, and a critique. He is in his own way challenging and critiquing Proven's video by the use of his own video. He does use the copyrighted work, which is plaintiff's video, which the court takes at face value was filed and thereby copyright protected. Now, whether that copyright protection will be upheld in a full-blown trial, I don't know, but I assume for the purposes of this hearing that it is a copyrighted work entitled to protection. The nature of the copyrighted work is barely artistic, but as artistic as Mr. McNally's response video, so they're either equally artistic or equally not artistic. So the artistic thing here is that things that have a higher degree of artistry get a higher degree of protection. If I write The Lord of the Rings, that will get a higher degree of protection than if I write a cookbook, because they're different, right? The cookbook is primarily factual in nature, right? You put in 12 pounds of salt and whatever else. That's either cooking for an army or it's going to be real salty. But yeah, in any event, it is either a wash or lends to the favor of Mr. McNally. The amount and substantiality of the portions used in relation to the copyrighted work as a whole, he used, I would say, to use his word, a smidge of the work, but it was enough to present what Proven was trying to claim. So it is substantial enough, but no more than is necessary to make the point that he's trying to critique Proven's video. And I think that's fair game and a nominative fair use circumstance. So when they look at how much you use, let's say I say I am going to critique The Lord of the Rings. And so my critique is basically I print the entire Lord of the Rings as a book. I'm going to print it all 3 volumes as one book. And then at the end, I just say, this sucks. Well, am I really using as little as possible in order to make my commentary? No, right? And even if my commentary ends up being as long as the work itself, well, it's still going to be really hard to argue that I'm using as little as the smallest amount necessary when I've used their entire book, right? The court says it was not greater than necessary, but it was enough. And the case law suggests that even a full recounting of the copyrighted work would be fine if that's necessary to set the stage for the critique. I used the full McNally video, and I'm pretty sure I'm within fair use because in order to comment on it, I have to talk about what's in it, and what's in it ends up being necessary to be the full thing to show the progression. The effect of the use upon the market for the copyrighted work is a little tricky here because, of course, the copyrighted work is not being sold. The copyrighted work is being used to sell the product of Proven. And so if I take a logical view of that, not this sort of strained view the defense would like, i.e. the court's throwing some shade at McNally too, or at least his team, there is a market for the copyrighted work that's tied to the market for the sale of the goods. Now, this is a place where I worry that the judge might be stepping into a problem, because the prior fair use, and I'm not going to be able to come up with a citation by memory here. I should have had this prepared. Oh well. Prior notes have basically said that if you this comes up with parody, right? Let's say a parody might destroy the market for the original, but not by competing with it, but just by making the original seem so stupid that no one wants to watch it, and that's allowable, right? Let's consider an extreme example, right? Let's say that there is a politician, we'll call him George, and George is running for, he wants to be mayor of whatever town. And he puts out an ad where he's like, I'm George and I'm the greatest. And I make fun of him. I put out a thing that uses his ad, and I make his ad look so stupid that now every time George runs this ad, it just makes him look stupid, because they think of how badly I've critiqued George. And, not only do I blow up his use for that ad, I blow up his entire campaign, because I am just so incisive that I destroy George entirely. Well, that's actually what fair use is about, right? Fair use at its fundamental level is about the ability to make those kind of critiques, to, in fact, and especially in like the political sphere, being able to completely flatten a politician because you are criticizing their bullshit is what it's why the fair use exists. So, yeah. Now, I don't think the judge has stepped over into that error. I'm just concerned that there is the potential for it. So, in any event, the effect is the intended effect, and it's not an improper effect. It's been used to critique the claim that these devices are impenetrable, and so it is at best for the plaintiff a wash, at best for the defense a defense lean. I would actually say that my assessment would have been different than the judge's, and I respect the judge's assessment, but my assessment would have put this as a strong defense factor here. And so, as to the 4 factors, on a motion for preliminary injunction where the plaintiff bears a substantial burden ahead of full litigation, the court says that the copyright claim fails as a basis for a demand for preliminary injunctive relief. Again, that's not to say it will ultimately fail once I see all of the facts and circumstance after full development of the record, but on this motion for preliminary relief, the claim does not support a preliminary injunction. As to the defamation by implication claim, as I think all the parties acknowledge, there has to be a defamation under Florida law, and it has to be tied to an independent tort. And here the independent tort that the plaintiff is trying to tie it to is the independent tort of tortious interference with a business relationship. Now, the court's going to explain it better than I would, so we'll let them continue. And of course, for there to be a tortious interference with a business relationship, there are the internal factors. 1, the existence of a business relationship that affords the plaintiff existing or prospective legal rights. So let's say I have a contract with, Joe's Widgets, and Joe's Widgets is going to sell me, 1,000 widgets a week at a particular price, right? That's useful to me because I'm going to turn around and resell those widgets in my retail stores for a profit, right? So, yeah, that would be an existing, business relationship. The defendant's knowledge of the business relationship. You can't be, in order to interfere with a business relationship here, it has to be an intentional and knowing thing, right? Because otherwise you could get lawsuits for everything, right? Like if I say hey, I went to McDonald's and the burgers sucked, it's going to affect some sort of business relationships, but do I know those exist? No, right? In the case of Joe's Widgets, if somebody intentionally went to Joe and said, I will buy up your entire widget stock, and I know you've got a deal with Runkle, but I want you to not do that deal because Runkle is terrible, then that might qualify because he knows he's got the deal with me, right? The defendant's intentional and unjustified interference with the relationship and damage to the plaintiff. So those are sort of the elements there. 2 of these factors are missing on this record as it's been developed to this point. 1 is the existence of a business relationship that affords the plaintiff an existing or prospective legal right. There's no outstanding contract that anyone has offered up to the court for the continual sale of these locks to a business that always purchases these locks that I've seen in this record. Now, they might be able to find that, right? There might be some RV company or something that buys these things and sells them to other people and is like, nah, we're not doing this anymore. So they might actually be able to solve this problem. Proven, this is a potentially fixable problem if Proven has those relationships. And if they don't, then they should lose, right? There are repeat customers, but Florida case law says that the fact that you might have a repeat customer who's dissuaded to buy your product due to a criticism of the product is not the type of business relationship the tortious interference with business relationship concept is intended to apply to. There has to be a contract or some clear business legal right to that relationship, and the defendant has to know about it. I don't know how they'd show knowing about it, right? Even if Proven is like selling to like, you know, RV God or whatever, like 1,000 units every, 3 days or whatever, how would McNally know that? They'd have to show that, and that's going to be a big problem. One of the first questions I asked at the beginning of the hearing is whether there is a return policy or a warranty under which the plaintiff operates that forced them to give back money to customers or that allowed customers to rely on that right in pursuing some return of the product that they now don't want because they've looked at Mr. McNally's videos, and I think counsel turned to the back of the room and got some affirmative nods of the head, but no evidence was offered on the record of this case to that effect. So it looks like customers read the video or saw the video and thought, oh, wow, I don't want this lock anymore. Put it back to the plaintiff, and the plaintiff did whatever it did, and it's not even clear what it did. And the plaintiff is losing customers because the customers aren't coming back or coming to them in as robust a manner as they might have before the McNally video. But this anticipation of continued growth in a customer base is not the type of business relationship to which a tortious interference with business relationship claim would support, and therefore the underlying tort on which this claim by implication is based, and so on. The preliminary injunction motion, the plaintiff hasn't met this very high burden. Holy crap, that's an entire sentence. Like, that sentence was like 20 minutes long. Sorry about the length of this video, but yeah. So basically the court is saying, Proven, hint, hint, do you have a contract that allows for customers to return these things? And if so, could you bring that as evidence? That might be helpful to your case, and you didn't do it, so maybe. It's very hard to do without a full development of the record because it is a prior restraint of a person's First Amendment right to talk about whatever they want to talk about, and so Florida courts put a high bar to establishing a basis for a tortious interference with business relationship claim that is part of a defamation by implication claim. It's not like Mr. Turkle said, but it's never been done, or it's not like Mr. Turkle said it's never been done in the history of the law before. But it's hard. It's hard to make out a claim like that, and it's even harder still to do on a preliminary injunction, which has its own high bar above the claim itself. And so the court finds that the plaintiff has not met its burden of proof in the case as to either of the claims, and so the motion for preliminary injunction is denied. Now here they give a specific warning to Mr. McNally. The judge is like, Mr. McNally, fuck around and find out, is what this warning is. Mr. McNally, you operate at your own peril if you continue to post these videos and say these things. That is, you operate at your own peril is legal speak for fuck around and find out, right? And I don't know what is happening when you're off video. I'm not sure if those boxes were opened or closed when you stuck your little lock magic thing up at the Amazon box station. They looked to me in a couple of videos like the door was already open. But you operate at your own peril to say right things and correct things and truthful things about the plaintiff's product, and the plaintiff has to bear up the burden in these difficult claims to sustain as the case progresses through the discovery and litigation phase. And I don't know, so basically, she's like, Mr. McNally, so long as what you're saying is true, you're going to be fine. But if you are bullshitting in those videos, the judge is warning, you might end up writing some big checks at the end of the day. That's what the judge is saying. Like, you got to decide if this is something you want to do because you're potentially in some shit. The judge also has some words for Mr. Sansone, and I don't know who Mr. Sansone is in reference to Proven. I'm not happy about his affidavit and declaration to the extent it fudges his relationship to Proven. So someone needs to revisit that declaration in regard to any future representations he makes to the court, Or at least Proven and Dynamic need to get together and decide who he is with reference to those industries. When the court says you might be fudging in an affidavit, that's a very bad place to be. Yeah. And then we get to some things that lawyers find funny, and you may or may not, but I found it funny, so we'll just end off on a funny here. The court asks, how much time do you need to file the amended complaint you'd like to file now? And Mr. Fahey, who is for Proven, says, 14 days, 7 days, whichever your honor sees as reasonable. And the judge says, lawyers can't do anything in 7 days. That's been my... And he says, 30 days. He goes for 14 days, 7 days, whatever. And the judge is like, really? And he's like, 30 days. The court says, all right. The court will give you 21 days to file the amended complaint that addresses concerns that are now pivotal and important based on how you've seen the case present in a hearing before the court, which is a subtle clue from the court saying, you might have some problems based on what happened here. Think, think, think. And then the defendant will have the reasonable course of time to respond to any such amended complaint. And the response time, obviously, to the existing complaint is terminated. No response is required to the complaint at this time. So basically, she's saying to McNally, you don't have to respond because that complaint is dead in the water. We know they're filing an amended one, so don't bother responding to that one. You only will have to respond to the real complaint. Again, an entirely reasonable thing. So, and then Mr. Turkle decides to do something dangerous. He decides to be funny with the court. He decides to tell the court a little joke. And it goes over part well. Mr. Turkle says, I just thought of one thing, Judge, that a lawyer can do in 7 days. And that's try a 4-day case. I think that's funny. The court thinks it's partially funny. And the court says, the what is due? The court hasn't properly heard him. Says, I said I thought of one thing lawyers can do in 7 days, and that's try a 4-day trial. He's joking that trials tend to run long. And the court says, yeah, that is absolutely true. And you can just tell that the judge is going to be leaning forward to deliver this last part. This is a lean-in situation. Except not in front of me. Isn't that right, Dave? Court plays that off into a don't test me. Like, okay, it's wonderful that like I get your joke. I like your joke. Your joke is good. But also that joke better not come true, because if there's one thing judges hate, it's when trials run long. And I mean, that's reasonable for judges to hate, right? Because everybody's got stuff scheduled, and when a trial runs long, suddenly you're into the mess of where else you're going to go. So it is always a little bit of a risk when you tell a funny to the judge. I appreciated it. I liked it. So, but the judge is like, that's funny, but no. I have had mixed success myself with with jokes to the judge. So I generally find the best strategy is to leave them off. All right. So that sort of wraps up that, hearing. The transcript, I think, is going to end up on Court Listener, so you can probably obtain it for far cheaper than I did, because I ordered it direct from the source. But yeah, those are the moments I thought were most relevant. Now, if you get the whole transcript and read through it, you might have different takes as to what's most relevant, but that's my reading. And I mean, my reading is going to be at like 2 hours, so yeah. Thank you guys for watching, especially if you've made it this far. I hope you found this to be interesting and educational. It really is a bit of an advanced view. Both sides, if they're smart, and I have no reason to believe their lawyers aren't smart and good at their jobs and so forth, are probably going to be picking over this transcript and their memories of the proceeding to go, all right, how's this look? Like, that's going to be a big thing for, settlement discussions and so forth, is what happens here. So, yeah. I think overall, I mean, obviously this went better for McNally than it did for Proven, because they they win the ruling at the end of the day. But I think the evidence came out better for McNally than Proven was probably hoping. And yep. So thank you guys for watching. I hope you found it to be interesting or educational. I have a link to my Patreon below, so if you want to support that way, I want to thank my Patreon supporters at the $50 level: Bottle Shock and Oz, Canada's National Firearms Association, the Canadian Shooting Sports Association, the Canadian Coalition for Firearms Rights, PJ's Forever, Angela Skelton, Cielo, Kyle Fox, Purple Dragonair, and Shay B. And at the $20 level, Mark, Lindsay Metcalf, Larry Kalniak, Drunkle of the Baileys, Cameron Johnson, and Marvin CZ. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. Hope this armed you with knowledge. See you next time.